May it please your lordship. But we are back to mention item number 24, lordship. Yesterday we filed an affidavit. I may be allowed to tag it with the file. Item number 24.
Serial number 24.
Yes, your lordship. Yesterday we filed an affidavit. I may be allowed to tag it in the file.
You are for the petition.
I am for the petition. Oblige.
May I please your lordship. For lordship, I beg to mention one retapil file yesterday, my lord. My lord, there is some urgency as because largest single judge has dismissed my petition and direction was given to hold the election of the cooperative society, man. And authority is going to, my lord, have the election. Day after tomorrow. Most of it.
May I please the lordship, my lord, with due consent from the other side, I beg to mention item number 5, my lord. The matter may be adjourned for 2 weeks, my lord.
Next, you overtake. Here,
May I please your lordship.
item number 32, I have taken it from the respondent side. Consent from the respondent side, item number 32. Would you like to go for mediation? Actually, the discussion is going between the parties. So therefore, if you want to discuss in a mediation proceeding, we can pass that order. By took 2 weeks times. After then I will be. Yes, counsel.
I pray for listing of a retapil for Thursday, my lord.
What is it about? Fresh matter,
Press matter.
permit.
May I please your lordship? I beg to mention the retapil for listing, lordship. There is some urgency, otherwise the retapil become infrastructure.
Sir, registry must be listing every. This is the first day that listing is being mentioned. Move the registry. It will automatically come if it is without any defect.
Lordship, kindly list them at around day after tomorrow, lord.
Therefore, day after tomorrow. Sir. Inform Arup, we don't keep any matters fresh in the registry without listing.
May I please your lordship? Lordship, I'd like to mention item number 25. Lordship, we have filed an IA impediment for party, lordship. The same has need to be brought on record, lordship. May I take this matter some other day, lordship?
May I praise your lordship? I am praying for item number 42, lordship. I have to file affidavit in opposition and I have taken consent from the other side also. 4 weeks time may be granted, your lordship.
Next,
May it please your lordship. Your lordship, with the consent of the opposite party, I beg to mention item number 6. Lordship, the conducting advocate is unwell. Hence, the matter may be adjourned today and 4 weeks time may be granted.
so you are for the appellant or
Appellant, your lordship.
but you were to file reply.
Yes, your lordship. Your lordship, he is unwell. The conducting advocate.
May I please your lordship. I beg to mention item number 29. Lordship,
Twenty?
affidavit is sent for vetting. Item number
23.
29, lordship.
29,
Yes, lordship. The affidavit is sent for vetting, lordship. Matter may be taken up after 3 weeks.
but early bird.
Yes, my lord, I appeal for the petitioner. My lord, there has been some development to what I have been instructed by my client. He has seen certain newspaper report that some kind of eviction drive is going on. What they informed me yesterday was to bring all these things in record to an appeal.
Early birds have become late birds now.
My lord, at least something is going on.
Okay. Next,
Please, your lordship. With the consent of other side, I'd like to mention item number 31. One of my senior, Mr. K. Singh, is unwell.
next,
May it please your lordship. I beg to mention item number 14. With the consent of the other side, I pray for the matter to be listed in 2 weeks, my lordship.
it is now pending for hearing. We will list it in the hearing. Where to be listed in hearing list number 2. Hearings are complete. It will come up for hearing now. There's no need of mentioning. Next.
Item number 1 to 3 of daily list.
There was an order passed by this court to take steps. We are down below 5 candidates whose name appears. Now we have taken steps to the director We just give a copy to the photocopy. Yes.
They are
received.
served.
I'm sorry, my lord.
Are they served?
They have been served. They have received. They have received. But this is a Mizoram, my lord. They have to come and engage a lawyer. I don't know. The admission, I think when it is the admission,
Admission will be completed by 16th of December and classes will start from 20th of December.
Then next Monday. When are you coming back?
No, next Monday I'm there.
Next Monday.
I'm also there. No,
Come on, right.
reasonable date.
Some time has to be
time
given,
should be
my lord.
given
No,
to them.
yesterday I telephoned my brother to inquire that you had mentioned some date that you are not available. Therefore, I am repeating what I inquired from my brother. You mentioned about some constitutional bench matter.
Yes,
Therefore,
my
I
lord.
was
On
not-
6th December and 13th December.
My lord, if it is not inconvenient, there is some AGT case in Calcutta. Both we will not there on Monday. So maybe on Wednesday, if it is not
এক second, এক
inconvenient.
second.
I-
Wednesday কিমান হ'ব?
24th.
20
In that case, let it be on 22nd.
25th will আহিব
দিনা দিন, দেৰি হ'ব, দেৰি হ'ব।
24th,
Okay, okay, 23rd, my lord.
23rd.
23rd.
Wednesday,
Oh, Wednesday.
Diary matter.
deeply obliged.
Letter number 45 of supplementary list for motion.
Yes, what is,
My lord,
what is brewing in your mind?
my lord, I have already deposit 50 lakhs rupees through RTGS and rest of the amount by check I am depositing.
Lordship, as per my instructions goes, we have got only 50 lakhs and the total amount as on 30 was 18 crore 69 lakhs.
The only thing is counsel that you have got something,
Yes, sir.
Now, at least 10% comes to 1 crore
No, no, no.
80 lakhs,
you have got something,
50 lakhs.
otherwise you have to
Rest of the amount.
wait till judgment of the London court to get even 5 rupees. Instead of that, you are getting 50. Don't take any action till 24. We are not passing any order. Not any order. CRT is available from 24th,
25th, I suppose.
25th.
25th.
So don't take any action till 30th of this month. Let him, then we'll pass appropriate order, tell him to go to poverty.
Right.
CRT.
And they will deposit the check today. it's correct.
That they will have to, otherwise it will not.
Yes, my lord. In fact, check is with me. I can deposit to him.
Hold Mr.
No, yeah, how can I?
Mr. P. Sharma for the appellant, for the petitioner. Says that the petitioner has deposited an amount of rupees 50 lakh
50 lakhs.
to RTCS in the respondent bank. Then a counsel for the bank also does not dispute the said fact. Mr. Sharma further submits that check of rupees
80 lakh. 50 plus 30, yes, 80 lakh.
80 lakh.
80 lakh.
80 lakh shall be deposited with the bank today. The same may be handed over to Mr. So-and-so learned counsel for the bank. Adjourn to 28 November.
My lord, one line maybe can be recorded because my lord, otherwise, if they can take any actions, I will be out of the complete business.
The bank shall take into, shall give receipt of the amount received as per the order of this court. The proceedings are adjourned to, the matter is kept on 28 for further order. I do worry.
Any direction to them for not taking any action?
No, then it would amount to, you say your end. Mister. You say your end.
Yes, sir. Till 25th.
No, till 30th.
That is.
Till 30th.
Mr. Nandi, learned counsel appearing for the bank, states that no further action shall be taken by the bank.
Diplomat.
30th of November.
Diplomat.
Matter number 7 of daily list.
May it please your lordship. In this case, the election of the BOD could not be convened.
May it please your lordship, lordship, I am for the department, my lord. My lord, on the last occasion, my lord, lordship had said there is a writ petition pending, my lord, the WPC 3391/2022, my lord. Lordship had said that after the disposal of the writ petition, my lord, writ appeal will be taken up, my lord. The writ
Yeah,
petition is
also-
pending, my lord.
When is it listed before the?
My lord,
Day before yesterday.
yes, my lord, on 11/11/2022, my lord, it was fixed after 4 weeks, my lord.
The petitioner side has taken time to file a rejoinder.
It's to 19th December. In view of the fact that the writ appeal number,
Not writ appeal, writ petition before the single by
give the number
number.
My lord, 3391/2022.
3391 of 2022 is pending before the current single judge. Next,
Oblige.
Obliged, lord.
Matter number 8.
May I please your lordship? Lordship, matter pertains to land acquisition, lordship.
yes, Mr. Pura, what are your instructions?
My lord. Section 48(2) does not apply because the initial stage, at the initial stage, after issuance of this notification, preliminary notification, it has not been further proceed because the land was required for the army personnel for
No,
construction.
You turn to page 41.
41. Lord. 41.
Sorry, 42.
Yes,
Read from the first line.
under section 48(1) of the Land Acquisition Act 1894, the government of Assam withdraw from the acquisition of land required for the Indian Army.
Now,
In
which
village.
is the land in question?
Land, yes, these are the land in question.
No, land of the petitioner.
Land of the petitioner, my lord. Within this, my lord, there are so many diagram and photo number is there, my lord, with Chita.
They have marked with pencil and it is xerox after that, so we also have benefit of it,
My lord,
which you also must be having.
Yes.
Now, on what basis is Mr. Bora?
my lord.
Under the old Land Acquisition Act,
Oh, Land Acquisition Act, yes.
listen to.
Yes.
There are two eventualities of releasing the land. One is section 4 notification is issued, but declaration under section 6 is not issued.
Not it.
Then they are not entitled to any damages because then it does not
Yes.
become property of the government.
Yes, right.
Secondly, they relinquish at the stage of section 6 itself.
Yes.
They don't include in the declaration, then it goes.
Yes.
Then there is no acquisition.
Yes.
Then no damages are provided. But when section 6 notification is issued, but possession as envisaged under section 16 of the act is not taken, then you can exercise powers under 48(1).
Yes.
Which you have exercised under at page 42.
Yes, 48(1), well, their exercise, well, rightly has done by the
Then
deputy governor.
if you exercise 48(1),
Yes.
you can't say that it was released at the stage of section 4.
No,
The officer who has given you the instruction is telling you a wrong thing.
no, that is, my lord, the deputy commissioner himself said in the affidavit, my lord.
Your
Yes.
deputy commissioner will be taken to task. You ask him to remain present here by 2 o'clock.
This is from Kasar, still, sir.
Then tomorrow,
Tomorrow, Lord Deputy Commissioner, he was on
Mr.
leave.
Bora, you take proper decision. Otherwise, if we find that it's a false declaration, we will take action against your
No,
DC.
yes, but Lord,
Huh?
obviously, my lord, that,
Let us be very clear. And it is a declaration before a court.
Yes.
So
Yeah.
you are aware about IPC provision.
that the affidavit, that means it's like, my lord,
Huh?
that's why I'm referring to the affidavit.
But
And
we are referring to your own notification.
Yes. On the basis of this affidavit, Honorable Single Judge has rightly dismissed the petition, only because of this.
Maybe.
No.
Then call your DC. Whoever has filed this affidavit.
Then Lord, may fix it on Monday.
That affidavit filed by,
Let us see on what basis he has filed the affidavit. Shekhar Datta, where is he yet present? He is the president, or he is the petitioner.
Gokul Mohan. Deputy Commissioner himself filed.
Gopal Hazarika.
He is not there, now some other deputy commissioner is there.
No, we want this fellow to be here.
Then,
Because if it is a false affidavit, we can't take action against the present TC,
then I have to verify where he is now.
wherever is he.
Yes, where is he?
Because you are relying upon it.
Yes.
And your secretary revenue also will have to remain present. Both the person.
Right.
Because I want your secretary to know that this type of pens are being taken by the government of advocates in the court.
No,
So let them know also.
this is not.
Ah.
Although we are always submitting on the basis of the instruction received from our client.
Sir Bora, we understand.
Yes.
We permitted you to become counsel of this lady council. That does not mean that you break the court to other aspects.
Yes.
And when is learned advocate general coming?
He has not come. Tomorrow, I think he will come.
If you take this seriously, we will take it to the logical, and we are telling you in the open court.
Not, and logically it will be better.
Because your affidavit is contrary to your own record.
Yes.
You will have to satisfy that this record is wrong.
Yes, my lord, this 59, this land, Lord, can you see the letter 59? So, the land
It is by the acquiring body. It is not by the.
in
Let it
Bureau,
be done
yes,
official.
sir. In Bureau to confirm that the supplicant is not being proceed
That
for
we
acquisition.
we are with you. There is no difficulty.
Yes.
You are joining issue on the aspect that it is not released under 40, it is not released from acquisition under 48(1), where your notification says it is under 48(1).
Notification says 48.
Your affidavit is not sacrosanct. On the contrary, this fellow has misguided the court.
My lord, better to at least better to take the instruction from the present deputy commissioner. We also see what instruction comes from his side. Whether it is contrary to earlier affidavit or not.
Therefore, we are asking you one aspect. That if page number 42 is a notification under section 48(1).
Yes.
Now, the land of the petitioner is included in that notification or not?
That has to be, there, yes. Yes, yes, I got that point.
I am now turned to page 57.
57. The affidavit, sir.
Yes.
Yes.
Wherein it was confirmed that the acquisition of the subject had not been progressed well for acquisition and was found low lying, and also a substantial portion of remains flooded and not suitable to meet their purpose. Thereafter, requisition notification dated 12/10/2011 was published. Now, which is that? Page 42.
Yes.
Page 42 is that notification. He himself says it is the requisition.
Yes.
And then he says, but it is stated that the question land was neither acquired nor possession was taken from the patadar.
Yes.
48 can be exercised only when you have not taken possession under section 16. But on what basis does he say that it is neither acquired? Acquired acquisition takes place, you read section 6(3) of the Act. Please read subsection 3 of section 6.
The said declaration shall be conclusive evidence that the land is needed for a public purpose or for a company, as the case may be, and after making such declaration, the appropriate government may acquire the land in manner hereinafter appearing. This is subsection 3 of section 6.
Yes, This is the effect of declaration under section 6(1) and 6(2).
Your lordship may take up on Monday.
So you will have to show us that it was because your affidavit is very risky to understand. On one end, you say it was prerequisite. Under the notification which is issued under 48(1). And you argue that it is not acquired. I don't know who is the officer who has instructed you.
And your lordship, Monday I will come with a good instruction, my lord. And if necessary, the officer will be present here.
That's the request of Mr.
Deeply obliged.
Next.
Item number 9.
Anganwadi,
May it please your lord.
Anganwadi,
Lordship,
Anganwadi,
lordship, Anganwadi worker, lordship.
notice,
Case 70 is the lordship impugn order of the single judge, lordship.
notice.
Lordship.
We are issuing notice. Next,
The only thing that we have,
next. We have issued notice.
lordship, obliged.
Next,
Item number 10.
May it please. In
Yes.
this case, honorable single judge, madam, having held that the office memorandum, my lord, is in conflict with the, my lord, the statutory rule, my lord, rule made under Article 309. And also that, my lord, it is not as per the direction of the judgment of this honorable court. Nonetheless, my lord, they retain the, my lord, that OM by merely, my lord, suspending, my lord, though, my lord, direction has been given to, my lord, amend the rules. But my whole submission, my lord, the honorable single judge, having found that the OM is not, my lord, according to the, my lord, the judgment as well as, my lord, is in conflict with the rules, that ought to have been, my lord, satisfied. That is my lord.
no, but you have derived benefit of that OM.
My lord.
You are benefited by that action of the
To
state.
because the earlier order already said, my lord, the state has to, my lord, make the suitable provision by giving a, my lord, realistic opportunity to the persons who were appointed earlier, my lord, under the 1982 rules or 2003 rules.
Hmm.
So that was already, my lord, earlier there. Now that having reaffirmed by this honorable court, but by keeping the, my lord, the OM, my lord, under suspension, my lord, an indication, my lord, that, my lord, the moment the rule is amended, that will automatically will revive, but that is again in conflict with the judgment. That's what, my lord, so far as the, my lord, prescription of the qualification, etc., is concerned. Because earlier rule, my lord,
No, but you are benefited by that OM, isn't it?
no, not at all, my lord. Because they require, my lord, a graduate with 5 years, my lord, experience.
Hmm.
And while we were appointed at that time, it was, my lord, class 8 under the 1982 rules, and, my lord, under the 2003 rules, it was, my lord, HSLC, my lord, metric pass. But now they have given, my lord, graduation, my lord, for the purpose of promotion, my lord. That is, which is also the, my lord, direct recruitment qualification for the, my lord, junior assistant.
Notice. Next,
Obliged.
Item number 11.
Please, madam. Lordship, the petitioner was a CISF employee. He was recruited in 2010, my lord, went for training, completed the training, and thereafter, my lord, he was posted. Now, in the annual medical checkup in 2012, my lord, a murmur was found in his heart, and that led to an open heart surgery to rectify them. Thereafter, my lord, he had become fit. The hospital which had operated upon him has said he is fit to resume duties, but no strenuous duties should be given to him. The medical board, lord, considers this case, puts him in shape 2, and says that he is fit for sedentary jobs. Now they continuously extend the, my lord, probation period. And finally, my lord, in 2014, 4/2/2014, they terminate my services. Now, my lord, it is an admitted position that the ailment that was detected in tea is a post-service ailment. It's already there in the medical board's findings,
Yeah, but Mr. Nair,
lordship.
even if it is post-service, we are not examining from IT point of view.
Lordship,
The question is that a fit man has to be there in the forces.
fine, ma'am.
Therefore, and you have not been denied the other benefit.
No, I have been denied all benefits. I've been only given a 1 month salary, man.
But you are the medically unfit.
Medically unfit,
CISF, it is
Lordship.
impossible.
my lord, because if my lord comes to the findings of the medical board,
No, we don't want to commit that mistake of being appellate authority of medical board.
no, I'm not on that. I'm only saying that the medical board had recommended a particular nature of job for me.
But is it binding on the authority? It is. not.
It is binding because my lord, section 47 of the, at that point of time, physically, my lord, the persons with disabilities rights and full participation. Section 47 says, if a person after joining service is inflicted with an ailment, then my lord, he should not be put out.
Maybe.
Section 47, my lord.
So Mr. Nair, whether it
Lordship.
will apply to armed forces
It
or not,
applies per se to all,
logically it does not set in.
but there is no bar as such, my lord, in the act.
Because unfit persons cannot be
My
recruited.
lord, I'm
in
not
a-
unfit.
Huh.
I'm not unfit, my lord. I am fit. If your lordship can just,
No,
have-
Mr. Nair,
lordship,
see, you can go to a high altitude, for example, looking to your physique. I may not be, but I am not unfit because I can't go to the high altitude.
lordship,
It is just like that. But in
Lordship.
common parlance, yes, but this is an armed forces.
fine, my lord. They say that,
Huh.
my lord, they say, the medical board says, I should not be given a work of general constable. But
No, but
there are other works available. my lord.
Which works are available?
My lord may come to page 77, my lord. My lord would see serial number 5. Fit for sedentary duties, yes. Types of sedentary duties recommended, runner, storeman, mass.
We'll issue notice, let us see if we can
Lordship, lordship.
notice.
And if an observation can, if they can have some instruction, my lord.
That
on that-
learned single judge has already,
No, the learned single judge, my lord, after coming into the conclusion that I should not have been sent out under Rule 25 on this ground, my lord rejected that prayer that I should be given a alternative appointment.
therefore let them come.
Lordship, lordship, lordship. Much obliged. lordship.
Item number 12.
Madam Lord, I have filed an affidavit yesterday. I think that it's not on your lordship report.
Come at 2 o'clock, we'll call for it. Next,
Item number 13.
The record was called for earlier occasion, Lordship. Whether written examination was called for or not, Lordship, in the writ petition, it is admitted that the written examination was called for, Lordship.
you are for the other side?
May I please, your lordship, this matter is conducted by the R. Muzumdar. He's done personal difficulty, lordship. But matter will be taken
Majumdar.
up anytime after 70.
R. Majmuda,
Yes, perfect. The standing counsel for the secondary education.
yesterday also he was absent. Today you have taken responsibility instead of granting care.
Lordship, any date after 70.
Mr. Majmuda changes mentioning councils also every day. 17th. You wanted 17th
Any date after 17, lordship.
after 7th. Give him some days. Whichever you start out. 2018. Next.
Matter number 15.
Yes, Mr. Pathak. Pathak is there.
There was a requirement to file an affidavit by the.
Mr. Pathak is there, isn't it?
Please, your lordship, I will call in lordship. Just
He
He's
was
on-
just here.
Yes, lordship. Just give me a minute. I will-
He was more worried about what would happen to his matter tomorrow rather than this matter today. Call him. I saw him there, therefore I was insisting. यहाँ से दिख रहा था कि पाठक भी वो आपके साथ क्यों गए इसलिए टाइम को टाइम दिख रहा है Yes, Mr. Pathak,
Lordship, yes, the affidavit has been filed, your lordship.
probably in your file only.
It is not with us. Copy has not been submitted.
Okay, I'll just check.
You give him a copy,
Yes, your lordship, I'll give it.
go through the affidavit.
Yes.
Take affidavit. Next. Okay.
Matter number 16.
Yes, Majmudar.
Lordship, Forest Department have filed affidavit.
Hmm.
It is, lordship.
Lordship, in the affidavit, it is admitted that earlier there was some illegalities and presently they have, because of the,
Page 20, para 2.
there are 2 years.
That video order dated 5/8/22 and passed by Honorable Court, it was directed that an affidavit be filed.
And the
है
detail.
मजमूदार आपके पास वो affidavit. That affidavit is there on record.
Yes, yes, I have received.
Hmm.
Lordship, may I read it now?
Please read.
The white order dated 5/8/2022 and 2/9/2022 passed by the Honorable Court, it was directed that an affidavit be filed to bring on record a detailed and up-to-date report regarding the alleged illegal sand mining in the riverbed of Dakshin Krishnapur. The Divisional Forest Officer Kachar has directed the Range Office Moinarkhal Range, Sonai, to take strict action against any illegalities. Further, the Range Officer Protection Squad Range Silchar was also directed to keep strict vigil at the Punabarigat Dakshin Krishnapur Minor Mineral Unit 1 within bracket play mining area against the illegal digging and selling of soil and sand of riverbank at Dakshin Krishnapur near bypass bridge. No illegal sand mining could be found to be carried out in the riverbank. All mining activities in the Sonabarigat Dakshin Krishnapur Minor Mineral Unit 1 within bracket play mining areas are carried out as per the guideline of the State Environment Impact Assessment Authority and the approved mining plan. Presently, the minor mineral unit is settled with Sri Babul Haq Lashkar for the period of 7/12/2020 to 7/12/2022. The mining area can be seen from the GPS coordinates plotted in the Google map. The range office shall maintain strict vigil to ensure that there is no illegal mining. Your Lordship, now I may be allowed to read the paragraph 3. That the deponent humbly begs to state that in the facts and circumstances as narrated herein above, it appears that presently there is no illegal mining in the concerned area due to the steps taken by the department and constant vigil maintained at the site of deponent is committed to ensure that such measures continue to be taken to prevent any such illegal activities. Lordship, my humble submission is that this petition may be disposed in accordance with the paragraph 3 of their affidavit.
Heard Mr. RZ. FZ. FZ. Majumdar for the petitioner. And Mr. KP Pathak for. You appear for which
Response
response?
numbers 1, 2, and 4 as for the forest department.
1, 2, and 4. And Ms. Bhattacharya ji for number 3. By way of this petition, the public interest litigate. The petitioner has prayed for a directing response number 3 and 4 in particular to stop illegal river trend mining at village Dakshin Krishnapur of Shahar district. More particularly in connection to the communication dated 3/01/2022 issued by DG District Development Commissioner Shahar. In response to the notice issued by this court, an affidavit in opposition came to be filed by response number 2 on 19th August 2021, wherein it was denied that there is any illegal mining. The said affidavit was replied by the petitioner. The response number 3 has also filed an opposition affidavit in opposition dated 25th of November 2021 and has brought on record the action taken, and more particularly it is averred that collection was not permitted beyond the demarcated area. Lastly, by the said affidavit has been countered by the petitioner by way of filing an affidavit in reply dated 10th February 2022. Pursuant to the same, further order came to be passed by this court on 4/3/2022, wherein response number 3 was directed to file affidavit. Accordingly, response number 3 has filed an affidavit on 4th April 2022, wherein it is averred that appropriate actions have been taken by the concerned divisional forest officer Shahar on 4/3/2021 against any illegal mining. Lastly, further orders came to be passed on 5/8/2022 and 2/9/2022, directing the authorities to bring on record the current position, present status of the mining. By an affidavit dated 11th November 2022, the respondents number 1, 2, and 4 have filed an affidavit wherein it is averred thus page 20, para 2 and 3. In light of the aforesaid, the grievance ventilated by the petitioner stands redressed. However, even while disposing this petition, the respondents are directed to adhere to the statement made in the affidavit and keep constant vigil over any illegal mining outside the demarcated area. The respondent number 1 here is directed to call for periodical report from the concerned range forest officer to and shall monitor and ensure that no illegal mining takes place. in the area info info, we were there. The petition is disposed of accordingly. No cause. Next,
Lordship, instead of the respond number one, perhaps the respond number two can be asked to monitor it. He'll be able to do it better. The
this one
PCC
number two, this one number.
Obliged.
Next,
Item number 17.
May I plead the lordship, my lord? I am newly appearing in this case, my lord. Yesterday we have filed affidavit, my lord. So it may come after some time, my lord.
meanwhile, LPRP called for, so as to receive court order before 12th of December, extend to 19th of December. Next,
Item number 18.
My lords, in this matter, we are filing affidavits in response to the rejoinders. We're filing rejoinders in reply to the affidavits filed by 4 and 5 and respondents 9 and 10, your lordship. They would not be on record today, your lordship. This matter may kindly come up after 2 weeks.
he overtakes. At the request of. Next,
Item number 19.
the mediation report is awaited. Mediation report is awaited.
On 4/11, the mediation, the
Agreement.
agreement was executed by the mediator.
When is it kept again? When is it kept? Is it over or
It is over, my lord. It's over. The
It's
agreement
over.
has been reached by the parties, my lord.
Okay.
And the respondents also mutually consented as per the direction of your lordships, my lord.
very good? So now you place it on record,
My lord.
the mediation report. So
My lord, we place it on record, lordship may fix a reasonable court date.
we can call for it from the mediation center.
My lord, my
My
lord,
lord.
my lord,
Come at 2 o'clock.
my lord.
My lord.
Keep your way.
Call for the mediation report. Next,
Item number 20.
May I please your lord. Why of it, then technical report. Not as- The illegal mining that has been going on in the Rota Cell and Gravel Mahal. Or if the case that your the mining that has been, although we have to the mining contract with Kellen, but we are not as such against the mining contract. The manner in which mining is being done in the area that our issue, which is violation of the mining plan, your lord, and your lordship, they have went beyond their your lordship demarcated boundaries, your lordship. They have used mechanized your lordship equipment which they cannot your lordship.
see, in consideration of your reply, Mr. Pathak, you appear
This is by the PTC.
PTC. See, we intend to ask some government authority to inspect the site and give us the report.
Lord.
Because considering your reply,
Lord.
it is little serious.
And your
Mr.
lord,
Pathak, any officer from the Forest Department of State of Assam can be nominated to.
Lordship, there is now, I believe, an additional special principal chief conservator for his BTC. Perhaps he can be directed to coordinate
Not from BTC,
from the government of Assam. Very well, your lordship.
you give us the designation and name.
Yes, sir. I'll just,
We are keeping it day after tomorrow.
yes, sir. Yes. Very well.
Next, it's the joint request day after tomorrow.
Item number 21.
Service is awaited. Await service. Next.
Item number 22.
Yes, Mr. Das.
I have seen the papers. I have heard something of fee. Solita of solid work management cannot be a dumping ground.
Pardon?
Solita of solid waste management cannot be a dumping ground. It appears from the record that the municipal board had initially tried a different place. Thereafter, there was protest, then shifted to the present place, Katimari, where the dumping is made. Photograph shows that there are people living around within the vicinity of that dumping site. We have below the 2016 rule. The rules are so futuristic below. So these are so detailed. Look, everything has been said. But from the record revealed that the municipal board has started from down below. The rule that provides the duty, people kindly take rule 11 for a moment. It provides for the duties what the municipal board has to do. So you also kindly turn to rule 11 page 34 for a moment.
Yes.
The Secretary Urban Development Department, the state or union territory, the commissioner or director of municipal administration or director of single bodies shall prepare a state policy and solid waste management strategy for the state or the union territory in consultation with stakeholders, including representatives of waste.
But Mr. Das, I don't think that there is any state policy.
There is no state policy. I found only one draft state policy. So this was the first thing that the state should have done before.
We are not examining that wider issue.
Right.
We are concerned with the dumping ground here. Our role is very limited.
If we go into that aspect of the matter, the solution is a proper RDF plan.
Whatever it may be.
That we have.
So you concentrate on the town in question.
Lot-
Because this is limited if you look at the prayers also.
Yes, madam.
It is only Silchar.
So this is
Or no
Nagaon.
count. No count. So we can't expand the scope to
Fine,
that
madam,
extent.
fine. That is absolutely right. But
Who appears for the municipality?
Myself.
What is your solution?
The land has been identified by the Honorable Deputy Commissioner as per Rule 12. It is a duty of the Deputy Commissioner. I may be allowed to read the rule itself.
No. Mr. Council, we are not on those technicalities. This hide and seek between TC and municipal corporation will not be permitted. Otherwise, we may have to ask them to take criminal action against all of you. So he may be having power of section 133 because it's a nuisance under CRP. You can't run away by throwing liability on DC, and you are a local authority. You get grants out of many things. We are not in any other era. Now we are in 2022. Those defenses we will not permit in PIL. Ask your officer, you call TC now, Ms. Bhattacharya. Whoever may be there. Call TC now personally. So that we can discuss with him and find out some way out. These matters are not to be put on affidavit. The general public is suffering because of it. Whichever practical way is there, he must suggest and we should implement it.
In fact, not we have already allotted them a sort of certificate, which according to us sufficient for setting up a certificate.
Therefore, you please call him
Lot.
and Mr. Counsel, you call the responsible officer from the board so that we can ask Mr. Das to sit with them and find out a solution. This is a phenomenal problem everywhere. No city is left. No city. Everywhere.
Guwahati suffered a lot.
Everywhere.
Yes.
Everywhere. So it requires solutions rather than state policy and all that. It's a wider issue. There, Mr. R.K. Bora and all will take care. They have officers to guide them properly. So I'm not worried about it. I'm only worried about this matter. When will it be possible? Personal appearance, we are insisting so that we can, on ground level, we can find out a solution. We'll keep it at 2 o'clock so that they can travel from Nogam very easily. They may not have to leave early in the morning, but I know it takes 2 hours. No. Any day in the next week, which is convenient, please tell us.
10:30 is the hospital lot. In fact,
No, 2 o'clock it is better. It's a, that, you have kept your other matters on this day. It were yesterday. 21st. Ask him to remain present on 21st. At 2 o'clock. Next.
Item number 23.
Service is awaited, sir. Await service. Next.
Item number 26.
Here also R5 is not out.
So 5 is being represented by Council Malad.
Achha.
I have put it 5.
Because report shows that they are not out, therefore.
Name is shown in the position.
Office not was say. Leave to appeal. What have you to say, sir?
So I have no objection, Lordship. Because I am holding the charge of the principal, Lordship. I am not a aspirant of that selection also. Here, Lordship, the honorable fingers are given direction for fresh consideration, Lordship. Yes, I am not a aspirant to that selection, Lordship. I have no objection, Lordship.
Who appears for the government?
Secondary department, Lordship.
Sir Majmudar would be there.
Okay.
Lordship, Patel is on the list.
Huh?
Majumdar. Majumdar, sir.
Mr. Majmudar would be appearing
No, Mr. Patel will be appearing. He is on the list.
2 o'clock. No, yes, come. Pathak has traveled from forest to education today.
I think 20.
We will pass appropriate.
Yes,
order.
sir.
Allowed. Allowed.
No infringement.
Next.
Memo.
Write down the appearance, please. Because office note says your name is not there. Please give the Pathak appearance not properly. Next.
Item number 27.
Please report is every.
The Coal India doesn't have a standing council. Who appears for Coal India generally?
Generally. Yeah, I'm happy to appear.
Sir, request him to come at 2 o'clock.
It is available.
Naturally, if he is available, we can't ask.
I think that.
So that first stage may be over 22
Yes,
days.
yes.
Delay may have 27 days or 22 days. So next. Come at 2 o'clock. Please request him on,
Yes,
on behalf of the court. Chalo next.
Item number 46 of supplementary list.
My lord, on last occasion, Lordship was pleased to pass order in item number 46. IA, my lord, 3206. There, my lord, while describing the respondent, newly imputed respondent, they should be, my lord, 91 to 245 instead of 91 to 140. 150.
So you want correction in the order.
That is one, my lord. Otherwise, my lord, today, there are two more IA before Lordship. That is IA 3215 of 22, where Lordship will pass similar order, Lordship has passed it.
That was.
Yes, one is implement. My lord, 3222 of 22 is the implement. And my lord, 3215 is the order, similar order as in 3206 of 22 Lordship.
So 3215 similar order.
Yes.
And what is the correction that you want in?
My lord, instead of respondent number 91 to 124, it should be 91 to 245.
We'll pass appropriate order.
Fine. My lord, in item number, IA 222 my lord, the respondents number would now be 246 to 279.
246 to
279.
please ask your AOR to
My lord, he'll give it.
Mr. Das. Please ask your AOR to prepare that chart type of thing so that we can incorporate in the order.
We'll give mine, we'll furnish. 3206 of 2022. The liberty was given, but I have been told that you go and practice Quran before the other signature. So that particular prepare, then after
But first, you will have to be
Yes, yes.
implemented. First we'll implement, complete you, then,
I 150.
yes, yes. Sir.
Yes,
So we'll allow that.
yes.
We'll look into it and pass appropriate
Fine.
order. Chalo, next.
Okay.
Item number 28 of daily list.
Yes, Mr. Das.
But yes, but is, we are agreed by the order of the third signature, we have been, what they have been working here under the ESI as a purpose. I have checked the writ petition, there is no affidavit filed by the government. Now, the learned single judge has relied to a rule, the pharmacy rule, 1986, but that rule is not applicable in our case. There is no rule as such. There was it was to an employment exchange on 8%. Ultimately, there was a board interview was taken. It is not a backdoor. Interview was taken, all different districts. Because, yes, and because there was an emergency, they want the required and supposed to be filled up. Now there is no affidavit filed by in the report by the government. So at least they should come up because that rule is not applicable.
Mr. Das, we don't mind doing that. But 2013 matter now after 9 years, we
But
tell
they
them,
did not file it by because I have checked it. This rule is not applicable in our case. Because they have not made any rule. It was bifurcated. It was health and family welfare earlier. Thereafter, it was bifurcated. After bifurcation, we were in the ESI as a pharmacy, and they have not made any rules. When the matter was taken up, I was not before the learned single judge. This rule was relied, but this rule is not there at all. Now what they have tried, what I have asked my client, they have come. Now they are considering to make a rule. There is a deputy message which was sent by the government. They said the interview will be held. There was a board committee which was, they said an interview was taken according to the select. And today is 2022, Mike. They have been working more than 2007 they have working at the department. Continuously we have worked.
Hello, this is health and family welfare. Health and family welfare.
who generally appears?
Yes, labor and employment department. Because that was bifurcated. Initially, it was a health and family welfare. Labor,
The appeal is pending since 2013. Mr. H. Das, the senior counsel appearing for the appellate, rightly points out that no affidavit was filed even before the learned legal day. Nobody appears for the concerned government authority. Response number 2, Commissioner and Secretary, Labor and Employment Department, Government of Assam, this court to remain personally present before this court to assist this court in this matter. On 22nd of November 2022. The Registrar Judicial is directed to serve this copy of this order. 21st. So he can retain his advocate, whoever is there from the government panel. 9 years, there is no advocate by the government. Next.
Item number 30.
Court মানে original report হলো seize করা। Original report হলো APSC record has been brought to the committee. Yes, yes.
Huh?
APSC record. Regarding this, in 2012, advertisement was issued for 14 posts of district military office. There was a written exam. At the written exam, there was an interview. They did not take into consideration any marks allotted in the and only on the basis of the interview. The selection was. The last time when the matter came up, the records were produced. And from the record, it was seen that the marks allotted by the there is overwriting in many of it.
Mr. Manta, you appear?
Yes, I appear on behalf of the APSC, my lord. What happened, my lord, already all original documents are seized in a criminal case.
Please.
There is, my lord, actually, their grievance is that, my lord, somebody telephoned them to asking money. And that regard, they have filed affidavit, they have filed FIR.
No, you produce the record before this court. Whatever you have.
Yes.
My lord, what had happened in this case, my learned friend, the clients are aggrieved by judgment passed by the single judge, whereby their writ petitions were dismissed. Now, my lord, what had happened in this case, the clients whom we represent, my lord, they were selected. But till that, they have not been appointed because of this proceeding. Now, my lord, the writ petition is a proxy litigation. What happened, my lord? Our order says, the moment we are appointed, the 3F appointees will be replaced. Now, just to protect the 3F appointees, my lord, this litigation has been, going on for quite some time. And my lord, one of the beneficiary of the 3F is the brother of the some joint secretary or somebody, my. Yesterday, I got to know. One of the beneficiary 3F, because of this proceeding, my lord, we have not been appointed and 3F are continuing. Fact of the matter is, we were selected by the Assam Public Service Commission. Now, let my learned friend argue on merit. Record losses will definitely look. What is their case? Learned single judge has dealt with each and every point.
Therefore, we'll call for the record. There are earlier orders also.
Yes.
And during the pendency of this case, without making a.
We are bound by the.
My lord, this so-called phone call that was of 16/8/2016.
Mr. Chaudhary, we are not
My lord.
considering phone calls. We are considering on merit, whatever it is there.
Yes, yes.
2 weeks.
Whatever available, because already
No.
original was his, but I call for photocopy, my lord.
Who appears for the government?
Like 11 record, all record are hit in the criminal.
Ms. Bhattacharya ji, you will be appearing or learned advocate general? No, but earlier learned advocate general appeared. Therefore, we are asking you. We have seen the other earlier order.
My lord, my only humble submission is, my lord, since this matter is going on, our appointments are withheld. Thus, we will have the matter next week, my.
Next. Every matter we can't give next week.
Oh, my lord. Lordship will see the, when Lordship sees the note sheet.
I have to wait for next month now, Mr. Chaudhary. Next.
Item number 33.
Two o'clock.
On some other date, it may be posted.
Some other day. Chalo, next. I don't think it is limited. Please. We'll look into it. Rubin by Declan. If the interim relief is limited, explain. Next.
Item number 34.
I could file the affidavit today only, Lord. It is filed. 18th, Lordship. I have some personal difficulty, Lordship. I have no problem if it is on Monday, Lordship.
23, otherwise 23.
Okay.
23. 23.
Deeply applied.
Item number 35 to 39.
May I please, your lordship? Could you kindly matter may take after a week? Advocate General is out of station. That's why.
Pastoral worker. Personal post.
Next.
No, my lord, that is our case. What we have said is, my lord, in the division bench, my lord, the fundamental rules are not considered. And my lord, there are Supreme Court judgment which says merely because a person is holding a post which is created for even for personal post, there cannot be any bar for promotion if the rules otherwise. And rules in fact provide a percentage of promotion.
Next.
High level.
Yeah. Only India. Yeah.
Lordship. Here also, Lordship, in item number 40, Lordship, 4041, additional advocate that is executing our take off. That the candidate taken for next week.
Next.
My lord, could it be at 2 o'clock?
These are all fresh matters. I don't know how it is listed.
No, my lordship was pleased to fix the matter for hearing.
Natural.
Actually, my lord, the one appeal is by us.
Give the. No, we are conscious.
Yes.
Where Mr. Majmudar did not, he wanted to argue the matter.
Yeah.
Actually, therefore, we have admitted it. Otherwise, we would have disposed it of, but he wants to argue.
Next.
Next.
Lordship was given next week.
Some date will be
But-
given. Passport. Where is Mr. Chaudhary? Passport.
May please, your lordship. Lordship, the R. Majumdar is conducting this matter due to personal difficulties. Lordship, matter may be taken up needed after 17.
Next.
No problem.
Present, your lordship refer to the Times of India news, my lord. I have gone for the judgment. And my lord, that is my lord, that case is regarding my lord one-time scheme, my lord. Payment scheme. Anyway, my lord, they have filed the affidavit. I would like to file the reply and your lordship may fix any date for hearing.
Today only. What reply do you file?
File the reply for the.
Look at your
That
prayer.
should be on
set.
record, my lord.
You ignore the reply. Turn
Beg
to
your
your
pardon?
prayer. You ignore the reply. Turn
I
to your
ignored this
prayer.
reply. Actually, I am not Well, my lord, taking antibiotic for fever. Because of this case, I have come, but not in a position because of the fever, my lord, in a doing argument.
Next,
Next week, my lord, any, next week, my
Tuesday,
lord,
next
that-
Tuesday,
next Tuesday,
next.
because I'm not feeling well.
Matter number 19.
I think mediation report has come now.
Mega pardon?
No, not in your matter. So we'll make this report as a part of the record and say that the parties to act accordingly.
My lord.
On the
No, it is fine. Now, what are you challenging in this appeal? The divorce petition was dismissed. instead of that-
my lord.
By the
Learned
So
family,
we will have to substitute it by way of agreement.
my lord.
And
Mutual consent.
Hold. Mr. T.K. Samra. Mr. Counsel for the appellant and Mr. P.K. Bhatia.
DK Boyd, my lord.
Mr. Counsel for the sole response. Feeling aggrieved and dissatisfied by the judgment and decree dated 8 October 2022 passed by Family Court Barpeta. TSM FC 9 of 2019. Dated 8/10/2021. The original plaintiff has preferred this appeal under section 19 of the Family Court Act 9. The Family Court, by way of the impugned judgment and decree, was pleased to dismiss the petition filed by the appellant plaintiff under section 13 into bracket 1 of the Hindu Marriage Act 1955 for dissolution of marriage between the parties, which came to be solemnized on
5/10/2012.
5th of October 2012 at village Karutapa, district Barpeta, Assam. Consider correct. In view of the fact that the dispute was regarding as the dispute was personal and decree of divorce was denied. I know this court passed the following order on 22/9/2022. Correct. Accordingly, the proceedings were undertaken by the learned mediator appointed by the Guwahati High Court Mediation Center. So, a report dated 9/11/2022 is placed on record today. Same shows that the parties have agreed for dissolution of marriage. Considering dissolution of marriage that came to be solemnized on 5/10/2012 at village Karupata, district Barpeta. The parties have also agreed that the respondent
Respondent, the wife.
shall have a right to file a
Permanent alimony.
separate petition for permanent alimony under the Hindu Marriage Act 1955.
Right.
The agreed terms and conditions are as under, quote the whole agreement, fixed for the parties to abide by the terms and conditions paragraph in view of the aforesaid agreement. Subject to right of the respondents to file an application as provided under section 25 of the Hindu Marriage Act 1955. The appeal is allowed and the marriage between the appellant, original plaintiff and respondent then dissolved as per the terms and agreement conditions of the agreement. Decree be drawn according.
My lord, the granting of permanent alimony is subject to outcome of the case which may be
That
filed.
is what we have
Which may be
stated. We have incorporated the whole
My lord.
LCR be sent back to the trial court forthwith. No court. Next,
Item number 27.
Deeply obliged, ma'am.
could you contact Mr. You are Mr. Ahmed?
Your Lotus, Mr. Andrew Ahmed is not well today.
We will condone the delay of 20.
That
Delay condone. आपका नाम लिख सकते matter to be listed for admission on 5th of December. Next,
Item number 43.
yes, Mr. Chaudhary.
Lordship, this is a appeal against the order of the learned single judge of the Mitaram bench.
Who are the opponents?
I'm waiting for the earlier information also.
Who others are appearing?
State of Mizoram is a party here.
Mr. Das is appearing.
Mr. Kalita was here.
K. Kalita.
A Kalita.
Presence would be required.
Yes, his junior. Now, Lordship,
Let him come.
yes.
Now, what is there to show that forceful possession is taken over?
No, Lordship, we do not. We have not taken post. It was in our possession. In fact, Lordship, the background would be like this, Lordship. The Assam Rifles, being the oldest Lordship from paramilitary report since 1933, was there. And in 1937, this property in Mizoram went under the ground. Thereafter, Lordship, in 1960.
Mr. Kalita, are you ready with the appeal?
Lordship, I have gone through it, but let's say if it can be picked up the other day. So our stand is clear, Lordship. We are supporting basically this people who has been uprooted from there.
No, we are conscious about the fact.
That Lordship, on record, he is not correct. No, we have filed an affidavit there. So we have stated so it's the affidavit. But anyways, Lordship.
But we may require original record from the office.
But that may be fine.
Looking to the issue involved. Because what is there to show that they were in possession from 76? Because if you go deep into the history since Second World War, this is occupied by Assam Rifles. And how they were put in possession from 1976 to 2000. And how learned single judge on what basis? There is no material on record. Yesterday I was trying to search that this. You see the judgment. Para 21. From the above extract verification report, it has been seen can be seen that the petitioners have been issued respective passes by revenue authority. In the Assam rifle on the other end claim right for the land on the 10th of 1960. As already noticed in view of the notification dated that the subsequent follow-up, the petitioners cannot be, I am of the considered opinion, cannot be deprived of rental compensation for forcible. Now, this is overlapping, Mr. If by an order of 2000 and 1960, rifles were in, how passes were issued by your revenue department? On what basis? Whether you support or you may be supporting on instructions for other purposes, we are not concerned.
I got it, Lordship. I
Ah.
got it. So Lordship, kindly
And
allow me
in a
some
petition under 226, with great respect, these conclusions arrived at on what basis?
Your Lordship, originally what had happened when the passes were issued, Your Lordship, to the Assam Rifle.
For Mr. Pathak. See, as I understand the system is this,
Lord.
You can correct me if I am wrong. If you put it in a chronological manner, you forget pre-1960 scenario. As Mr. Chaudhary started from 37, that is the initiation of the Assam Rifles.
Yes.
I know that. The question is that 1960 is the initiation of a document of title of this land. If you put it chronology, to forget that you are holding a matter. Just arrange it in chronology. Then first comes that order of 1960 by which Assam Rifles were there. So the title passes in Assam Rifles.
First title was in Assam Rifle.
Now, once the Assam Rifle title passes, when we say, I fail to understand one aspect, that on what basis the Revenue Department of State of Mizoram got jurisdiction to issue passes.
Yeah.
And where is the question of forcible possession? Forcible possession, even if we take shelter of provisions of the old Land Acquisition Act, then also who has determined the rental?
Yeah.
And rentals are paid to the owners, not the tenants.
To the owners.
It is paid to the owners even under the old Land Acquisition Act.
Yes.
Now, if in 1960 the Assam Rifle has become the owner, where is the question of your ownership by mere passing of a pass? It may be a permissible use.
Yes.
See, these cantonment areas and all areas, they are all protected. But
Yep.
in a state like Mizoram, if it is bordering a state, other country, there may not be cantonment as a whole, but the ownership was passed in 1960. This is what we want from Mr. Kalita to verify.
Yes.
Lordship, I'll do.
There was one notification of the government of Mizoram. I mean, they will bring the record just for your Lordship, where these land passes, Your Lordship.
Because Mr. Pathak,
Lordship.
see, you will agree with me that you and I can't impute our personal knowledge in this.
No, it's on record, Your Lordship.
Therefore, the learned single judge had no occasion to verify this fact.
Yes.
At the most, we may have to post this and remand the proceedings back to the learned single judge. We don't want to examine whether a writ petition would lie or not.
I'll try and satisfy Your Lordship on the next day.
Or